My name is Franklin Rawlins. Most folks in the courthouse used to call me Judge Frank back when my hair was still the color of courtroom oak, and tonight, with the cicadas outside timing my heartbeat, I'm finally ready to talk about the single ring of a doorbell that cracked 4 decades of silence wide open. Before we dive deeper, if stories of law, regret, and redemption strike a chord, slide that thumb toward the like icon or drop your thoughts below. I read every word. Retirement does strange things to a man's spare time, you know. I served the state of Texas from the bench for nearly 30 years, wore the black robe like second skin, and prided myself on chasing clarity in statutes the way a ranch dog noses through mesquite for rattlers. But no amount of precedent, no annotated codebook, no stern gavel could have prepared me for what I'm about to share, because what happened in 1982, and again, on my front porch last spring, reminded me that the law can issue orders, yet a conscience keeps its own docket. Picture the courtroom back then, oak panels soaked in fluorescent glare, rows of restless jurors fanning themselves with summons, reporters craning for a quote, and a 22-year-old defendant named Malcolm Ray Thomas staring me down with eyes that looked older than the chambers of my heart. He was charged with carving the life out of a Dallas businessman, a crime the city wanted avenged by Christmas, and the evidence, as presented, had the crisp edges of a Sunday headline. I did what the statute demanded, pronounced death by lethal injection, and climbed into my Buick that night believing I'd upheld the peace. Still, as the engine cooled outside my driveway, Malcolm's last words, "God knows, and so will you," settled over the leather seats like a stubborn fog. I shook them off, wrote the opinion, and told myself a judge can't afford second guesses, but second guesses have a curious way of accruing interest. Fast forward 4 decades, I'm 76, a widower, living in a Waco suburb where the loudest scandal is misplaced trash bins, and my idea of risk is an extra teaspoon of sugar in the coffee. One April evening a storm marched in off the Brazos, rattling windows and memories alike, when my doorbell chimed, a single, steady note that sounded patient. I opened the door, and there he was. Malcolm. Same eyes, same calm I'd mistaken for indifference when I sent him to die. In his hand, a weather-stained manila envelope, fat with something heavier than paper, truth, perhaps. I felt the robe rematerialize on my shoulders, every ruling I'd ever signed whispering in the hallway behind me. What he said next, and what I found inside that envelope, rearranged my understanding of justice like a clerk dumping files onto the floor. But I'm getting ahead of myself, and trust me, you'll want the full docket. So pull your chair a little closer, keep that finger near the subscribe bell, and let me rewind to the summer of '82, when a bright-eyed judge believed the law was a straight road, unaware of the sinkholes waiting in the asphalt. Because by the time this tale closes, you may find yourself questioning whether certainty is virtue or simply comfort dressed in legalese. And if my confession sparks even the faintest ember of doubt, I invite you to stoke it in the comments. I spent a lifetime interrogating witnesses. Tonight I'm putting the question to you. Take a breath, lean in, and remember, a verdict can echo longer than a sentence, and sometimes that echo is what finally wakes you from sleep. You know, I still remember the first time I stepped into a courtroom as a law clerk. The air heavy with polished wood and hushed anticipation, the faint scent of old paper and coffee lingering in the corridors. I was born in a small East Texas town, Gladewater, population barely north of 5,000, and from as early as I can recall, my world revolved around 2 things: the Sunday morning hymn at First Methodist Church and my father's stories of frontier justice when he served as county constable. I hung on every word, about the weight of a man's oath, the gravity of a single ruling. That childhood fascination propelled me through Baylor University and straight into Harvard Law School, where I learned to speak the language of statutes and precedents. By age 28 I'd clerked for a federal judge, then returned home to Texas with stars in my eyes and a black robe waiting at 34. When Governor appointed me to the bench in Dallas County back in 1982, I honestly felt I'd arrived at the summit of my ambitions. Every weekday began before dawn, coffee brewed strong enough to stir a ghost, newspapers spread across my kitchen counter, and my Harvard casebook stacked on the passenger seat of my Buick LaCrosse. In court, I prided myself on punctuality, opening gavel precisely at 9, barring any last-minute fireworks. The bailiff's "all rise" still echoes in my mind like a sacred refrain. My chambers, lined with law reviews and bound volumes of Texas reports, served as both fortress and sanctuary. Colleagues knew me as methodical, a pragmatist who kept emotion firmly in check. "Frank," they'd say, "you've got to remember there's a human story behind every docket." And I believed them, up to a point. I was the kind of judge who listened intently during opening statements, keyed in on every nuance of cross-examination, and weighed closing arguments as though each word might tip the scales of justice. Outside the bench, life moved at a different pace. My wife Susan, rest her soul, ran a small antique shop near the courthouse square, where locals came for refurbished oak dressers and family heirlooms. Sundays meant late church services, brunch on the patio, and walks beneath live oaks heavy with Spanish moss. I treasured weekends when the only briefs I handled were law reviews, and the loudest objection came from our terrier, Rufus, barking at the neighbor's mail truck. But inside that courtroom, my focus was razor-sharp: due process, burden of proof, evidentiary standards. I rarely indulged small talk. The law demanded clarity, and I believed clarity was inseparable from fairness. Yet even in that structured world, I carried a quiet restlessness. Late at night, I'd pore over cold files, cases dismissed for lack of counsel, trials hurried to meet political deadlines, wondering if I'd done enough. I told myself a judge must guard against sympathy, lest mercy undermine the statute. Still, every so often, I'd catch my reflection in the polished bench and think, to be honest, "Frank, you're chasing ideals you're not sure you can reach." And it was that tension between heart and duty that shaped my tenure on the bench for nearly 30 years. By the time I retired, the oak-paneled courtrooms had witnessed thousands of motions, appellate reviews, and plea bargains. I'd authored opinions that found their way into law school textbooks, mentored young attorneys eager to unravel constitutional questions, and presided over ceremonies where gavel met bench for the last time. Yet through it all, the scene that lingered most vividly was back in 1982, facing a young man named Malcolm Ray Thomas under the harsh glare of fluorescence, when I pronounced a sentence that years later would haunt every quiet moment. Because no matter how disciplined or pragmatic you aim to be, you never truly escape the ripple effect of a single decision. And that, more than anything, is what brought me here tonight, sharing not just a verdict, but the man behind the robe, the life behind the gavel, and the doubts that only grow louder with time. That morning in late September of 1982, the sun had barely broken over the skyline when I slipped into the Dallas County Courthouse, the air in the hallway thick with anticipation and the tang of fresh coffee from the clerk's office. The marble floors gleamed under fluorescent lights, and the portraits of stern-faced judges in their black robes seemed to track my progress toward courtroom 4B, as if they already knew what was about to unfold. By 9 o'clock, the seats were nearly full. The bailiff, Lieutenant Harris, stood at attention in his crisp uniform. A handful of uniformed officers hovered near the defendant's chair, and a row of local reporters, their notepads open, exchanged quiet chatter about how fast this case would move. I took my place behind the bench, adjusted my robe, and nodded to the court reporter, her fingers poised above the stenograph machine, ready to capture every word. On my right sat the city prosecutor, Glenn Hardwick, a lean man with wire-rimmed glasses and a reputation for pushing hard to meet political deadlines. On my left was a young public defender, Miss Evelyn Carter, only 25 years old and fresh out of law school, still clutching her briefcase like a lifeline. And there, in the dock, was Malcolm Ray Thomas, 22 years old, shoulders hunched, eyes steady even though he'd spent most of the morning handcuffed and shuffled through metal detectors. No attorney by his side until the third pre-trial hearing, they'd said. No time to prepare. I cleared my throat and called the court to order. All rise. The subtle thump of boots on marble reminded me exactly what I was about to do, preside over a trial that would end in a sentence no judge ever wants to pronounce. The jury filed in, 12 faces intent and unreadable, ready to decide whether Malcolm had used that butcher knife to take a man's life. I scanned the pile of exhibits on the evidence table, the knife wrapped in cellophane, blood-stained and cold, a stack of photos showing the victim, a white businessman known for late nights at the office, and the surveillance tape from the convenience store across the street, which, I was told, had a crucial 4-minute gap right at the time of murder. When the tape was handed to me, I peered at the spool and felt a flicker of unease. Lost footage in a capital case is like a missing piece of your own heart. I tucked that concern away, though, and looked out at the packed courtroom. "Prosecution, your opening statement," I said, trying to keep my voice even. Mr. Hardwick rose, buttoned his jacket, and painted a picture of cold steel and innocent blood, every word measured to stir the jury's sense of outrage. I watched Malcolm's jaw twitch as the prosecutor described the victim's last agonizing moments, then caught Miss Carter's eyes, wide, determined, but untested. When defense rose to object to the admission of certain photos, I listened carefully, weighing the rules of evidence even as my chest tightened. To be honest, I still get a knot in my stomach thinking about how that moment felt, like I was standing at a crossroads, and whichever path I chose would echo in someone's life forever. By the time we recessed for lunch, I'd already signed several orders and scheduled the next hearing, but I couldn't shake the image of that broken tape. There was a trigger there, I knew, a hint that not everything fit the neat narrative we were building. I closed my eyes for a moment, leaned back in my chair, and heard the dozen silent whispers of precedent and procedure urging me onward. Little did I know that the decision I made just hours later would stay with me, lurking in every quiet night, until a single knock on my front door 40 years down the road forced me to confront the gavel's heavy truth. By mid-afternoon, the case began to splinter in ways I hadn't anticipated. I was sitting behind the bench, the overhead lights humming as I reviewed the chain of custody log for the murder weapon, knife, item 14B, when Miss Carter, the public defender, rose with a hesitant look on her face and asked to recall our key witness, Mr. Simmons. I remember thinking, "You sure you want to do that, kid?" But the rules of evidence leave little room for paternalism, and I granted the motion. Next thing I know, Simmons is back on the stand, hands trembling, admitting that his initial testimony was coached by an investigator eager to close the case before the elections. My gavel felt heavier in my hand as I watched him retract every statement that had painted Malcolm as the lone actor. I still get goosebumps thinking how the jurors shifted in their seats. Some exchanged glances, others scribbled furiously. The courtroom air crackled with tension, like static before a storm. For the first time that day, I wondered if zeal for a quick punishment had overshadowed careful deliberation. Just when I thought the defense had the upper hand, the prosecutor stood and dropped what felt like a rhetorical bomb, a new affidavit from a jailhouse snitch claiming Malcolm confessed the crime to him. The affidavit arrived on the courthouse steps only that morning, and Mr. Hardwick insisted it was too crucial to ignore. My stomach nodded, hearsay, right? I leaned forward and asked probing questions about reliability and motive, but the snitch's record of dealings with the state prosecutor's office made the document suspicious at best. I could almost hear the political whispers echoing down the marble corridors. Hardwick needs a win before November. To be honest, I felt myself pulled in two directions: apply the law strictly and risk a possible miscarriage of justice, or admit a flawed piece of evidence and satisfy the very system I swore to uphold. My chest tightened as I ruled to admit the affidavit under an exception that I knew might crumble on appeal. I glanced at Malcolm, calm, unreadable, and realized the true dilemma had just begun. By late afternoon, the courthouse hallways felt less like a temple of justice and more like a theater of power plays. I had jurors summoned back to deliberate despite rising doubts, the stenographer's machine rattling like a metronome counting down the moments. Outside, the local news vans lined up under the canopy, their satellite dishes trained on the courthouse steps, waiting for a verdict that would make headlines. Every procedural choice I made, denying a motion to suppress the knife based on a flawed arrest report, allowing character testimony from a deputy under thin pretext, felt like a decision that might come back to haunt me. You know, I often say, I did what the law demanded, but that afternoon I wrestled with whether the law was enough. The weight of precedent, the pressure of politics, and the urgency of a gavel ready to fall all converged into a single, crushing moment. I closed my eyes, took a deep breath, and reminded myself that a judge's true duty is not to the fastest verdict, but to the fairest one, even if fairness moves at a glacial pace. Little did I know, that choice would reverberate through 40 years of my life, carving doubt into every quiet corner of my memory. That morning, the jurors returned to the bench with a verdict that would define the rest of my life. I watched them file in, faces tight with responsibility, hands clasped, eyes never leaving the gallery behind me. My gavel sat waiting on the bench like a loaded weapon, silent until called into action. Clearing my throat, I asked, "Has the jury reached a verdict in the case of State versus Thomas?" The foreperson stood, voice steady but tinged with gravity, and answered, "Yes, Your Honor." My pulse quickened as I absorbed the words, "guilty." In capital cases, that single word carries its own soundtrack of heavy breaths and silent prayers. I felt every second stretch like taffy as the foreperson read the verdict aloud, each syllable landing like a hammer on metal. Malcolm sat motionless, his eyes bore straight into mine, calm yet alive with unshed questions. I glanced at Miss Carter, whose lips pressed into a thin line, her innocence colliding with the weight of the law. The prosecutor exhaled sharply, relieved, triumph gleaming behind his spectacles. I rose, unfolded the verdict form, and announced, on the charge of capital murder, "It is the judgment of this jury that the defendant be sentenced to death by lethal injection." An electric shock pulsed through me. I still remember how the word sounded oddly distant, as if uttered by someone else. In that instant, the full weight of my robe pressed down, reminding me of every statute I'd sworn to apply impartially. I struggled to steady my voice, throat tight, mind racing with the gravity of finality. I said, "I hereby impose sentence as dictated by the law of the state of Texas," and rapped the gavel twice, once to punctuate the verdict, once to seal my own fate. A collective intake of breath rose from the courtroom as the sound reverberated off marble walls. Malcolm lifted his head, his jaw set, and spoke those words I'll never shake, "God knows, and so will you." The hush that followed felt like the calm before a storm, and for a moment, everything stood still. I felt the steady thrum of my heart in my ears, wondering if I'd misread a single piece of evidence. Amid the applause from the prosecutor's bench, I sensed a fracture in my own certainty. I watched as officers led Malcolm out, his shoulders squared despite the shackles, carrying himself as if in quiet defiance. The gallery emptied, reporters scribbled final notes, and I remained perched behind the bench, the gavel still trembling beneath my palm. Man, was it crazy to think a justice system built on certainty might harbor shadows the size of mountains. I returned the form to the clerk, each page a reminder of the irreversible nature of power. In the silence, I heard the echo of that 4-minute gap in the surveillance tape, a hole in our search for truth. I wanted to rise, call back witnesses, demand a stay, but the law offered little room for remorse once that sentence was pronounced. I closed my eyes briefly and caught a glimpse of the young judge I once was, so disciplined and unflinching. To be honest, I could feel the first tremors of doubt crack through my resolve, like a fault line opening beneath granite. When I reopened my eyes, the courtroom felt emptier, as if justice itself had walked out the door. The bailiff announced court adjourned, and I stood slowly, legs unsteady under the weight of finality. That was the moment the law became more than words on paper. It became a force I had unleashed without knowing its full reach. I left the bench that day feeling as though I'd crossed a threshold I could never unsee, never unhear. And as I stepped into the corridor, the hum of conversation resumed, Reporters jostled for a final quote, but all I could think was, I'm not sure my soul can live with this. Yet live I did, and for 40 years I carried that moment in the quiet corners of my conscience. That day remains the crescendo of my career, the climax where duty, doubt, and destiny collided beneath fluorescent lights and oak-paneled walls. By the time I closed the courthouse doors on that day in '82, I thought the matter was settled, final. In the weeks that followed, I signed the official paperwork, the execution date was set, and I returned to my routine of hearings, sentencing, and chambers conferences, telling myself that justice had been done. To be honest, I rarely thought about Malcolm Ray Thomas after that. I'd convinced myself the system worked, that any lingering doubts were just the residue of a hard decision. Then, 2 years later, I learned the sentence had been stayed because of technical irregularities in the arrest procedure. I filed the stay notice away in a folder marked "Closed," assuming that the wheels of justice would grind on and the sentence would ultimately be carried out. I didn't know he'd slipped away during a prison fire in the early '90s, trading shackles for sanctuary, or that he had reinvented himself as a pastor in New Orleans, guiding at-risk kids through gospel songs and Sunday school lessons. I'll never forget the day I found out he was alive. It felt like discovering an echo in an empty room, unexpected, unsettling, impossible to ignore. For decades, I carried a peculiar blend of relief and unease, knowing he lived but unaware of his new identity. When retirement rolled around, I moved to Waco, trading the bustle of Dallas for a quiet street lined with pecan trees. Widowed, with only my son's occasional visits to punctuate my solitude, I spent long evenings poring over old case files, though I never once revisited the Thomas file, too painful, too loaded with what-ifs. And then came that stormy evening when the doorbell rang. Lightning flashed, thunder rolled, and there he stood, Malcolm, the man I'd once condemned. In his hand, that yellowed envelope containing a signed confession from the actual killer, who had died the month before under suspicious circumstances. Inside, I also found photographic proof placing Malcolm miles away at the time of the murder, nothing short of exculpatory evidence that former prosecutors had buried for political expediency. I remember standing there, rain dripping off my coat, feeling the robe I no longer wore settle on my shoulders like a warning. He said, "I forgave you the day you sentenced me. I just wanted the record straight." I still get goosebumps thinking about how calm he was, how he offered me grace I'd never earned. That night, I sat in my study, lights low, the envelope open on my desk, and I felt the full weight of 4 decades of silence crushing my chest. I called every contact I'd made in the legal community, appellate attorneys, Innocence Project volunteers, reporters I'd once banned from the courthouse. I arranged to file a motion to vacate the verdict, and within weeks, the Texas Court of Criminal Appeals agreed. Malcolm Ray Thomas was exonerated, his name cleared after 40 years. I flew to New Orleans, where I stood beside him in a small chapel filled with the children he'd mentored. I watched him as he preached forgiveness, and as his congregation rose to their feet, I realized I'd found a measure of my own redemption. Back in Waco, I began recording a documentary podcast, Echoes of the Gavel, to tell the full story, warts and all, so judges and jurors and ordinary citizens could hear how a broken system can be mended when truth finds its way out of the shadows. I also drafted a memoir under the title, I Wore the Robe. I missed the truth, hoping that my story might serve as a cautionary tale for those who believe certainty is justice. These days, I divide my time between speaking engagements, law schools, bar associations, faith forums, and quiet afternoons with Rufus, my terrier, by my side. Every so often, a listener or reader will tell me they've re-examined a decision in their own life or career because of my story, and that brings me more pride than any judicial opinion ever could. The law without heart is no justice, and a gavel without doubt is a weapon. Those aren't just words to me, they're the lessons I learned the hard way. In the end, we all deserve a chance to open the door, to listen for the voice that sets us right, no matter how late it rings. I remember the days and weeks after Malcolm walked away from my doorstep as if they happened in slow motion, like watching a film reel that's been stretched too thin. I felt a curious mix of relief and lingering dread, relief that justice had finally caught up with truth, and dread that I'd spent 40 years under the weight of a verdict I wasn't sure I deserved. To be honest, I couldn't sleep right for weeks. Every time I closed my eyes, I saw those oak-paneled walls of courtroom 4B, heard the gavel's echo, and felt the hush that followed my pronouncement. I'd wake in the middle of the night, heart pounding, whispering to the empty darkness, I did what the law demanded, but not always what my soul could live with. In the quiet of retirement, I'd always thought I was coming to terms with my career, finding peace in lectures, mentoring young judges, writing that podcast script, but this revelation forced me to reckon with the gap between duty and compassion. I realized that a lifetime spent chasing legal certainty had left my heart a little brittle, prone to cracking under the weight of second-guessing. I started keeping a journal again, something I hadn't done since law school, pouring out every regret, every what if, every hope that I could turn this tragedy into a lesson for others. Working on the memoir felt like therapy, a way to stitch together the torn edges of my conscience. I still get goosebumps thinking about the day I visited Malcolm in New Orleans, standing in that tiny chapel where he preached forgiveness, and hearing the congregation sing, "Amazing Grace." It struck me then that mercy isn't weakness, it's the bravest thing we can offer. It reshaped how I viewed my own role in the system. I wasn't merely an enforcer of statutes, but a steward of lives. These days, when I speak at bar associations or law schools, I'm no longer the polished jurist who rattles off evidentiary rules with surgical precision. I pause. I share the creaking doubt that's been my constant companion. I ask young lawyers to remember that behind every case file is a human story and that silence can be as damaging as a wrong verdict. Man, it was crazy how long it took me to learn that. And though the news cameras have moved on and the headlines have faded, the aftertaste of that evening on my porch remains. It lingers in my conversations with my son, in the way I pet Rufus a little longer each morning, and in the quiet promise I make to myself every day, to never let the letter of the law eclipse the spirit of humanity. Looking back on everything that has unfolded, I realize the most important lesson I walked away with is that the measure of justice is not in the strict application of statutes but in how deeply we consider the humanity of every individual who stands before us. You know, I spent a lifetime chasing legal clarity, convinced that certainty was the highest virtue, only to discover that certainty can blind us to truth when we ignore the soft voices of doubt. I'll never forget the moment I opened that envelope and realized I'd sentenced an innocent man. It taught me that a gavel without compassion is like a scale without balance. What I carry with me now, every time I step into a lecture hall or a small group discussion, is a reminder to pause, listen, and ask myself not just what the law demands but what my conscience requires. It changed how I mentor young attorneys, urging them to remember that evidence is never infallible and that every file is a human life waiting in the wings. I learned that admitting a mistake isn't weakness, it's the bravest act of accountability a person can perform. To be honest, that realization came late, but it reshaped my understanding of leadership, service, and the role we play in safeguarding truth. Now, I advocate for processes that build in pauses for reflection and channels for voices that are often silenced by urgency. Mercy isn't about letting people off the hook, it's about acknowledging our shared vulnerability and the possibility of redemption. In the end, I discovered that a judge's greatest power lies not in the finality of a pronouncement but in the courage to open the door to truth, however long it takes. I hope my story encourages you to question the quiet convictions that guide you and embrace the doubts that lead to growth. After the court formally exonerated Malcolm and the headlines quieted down, my story took on a kind of life of its own among legal circles. Colleagues started referring to the Rawlins case as a cautionary legend, how a single gap in a surveillance tape and a rushed affidavit nearly cost an innocent man his life, and how a judge's second glance can be the difference between justice and tragedy. Invitations to speak poured in, Bar associations asked me to lead panels on evidentiary review, law schools scheduled keynote lectures on the human side of judging, and Innocence Project sought my insights on preventing wrongful convictions. I found myself in conference halls from Austin to Atlanta, sharing the Molly testament of my 40-year reckoning, and each time I spoke, I noticed younger judges nodding in recognition, many confessing privately that my story mirrored their own hidden doubts. Back in Waco, I was no longer just Judge Rawlins, retired. I became a de facto consultant for reform initiatives. I worked with nonpartisan commissions to draft guidelines that require courts to flag any case with missing or shaky evidence, and I volunteered with organizations that train defense attorneys in spotting procedural flaws. I still review a monthly docket of cold cases pro bono, collaborating with law students who remind me how vital fresh perspectives are when old judgments are re-examined. It's ironic, and a relief, that I've never again faced a capital case as a jurist, but the shadow of that moment in 1982 shaped every subsequent decision I made as a mentor, speaker, and advisor. Among my former peers, the tale of a judge who admitted error and helped right a wrong became a touchstone for humility and accountability. Senior judges who once saw doubt as a liability began to encourage candid discussions about uncertainty in the courtroom. Workshops on judicial self-reflection popped up in courthouses across the state, carrying my name as an example of how admitting a mistake can strengthen, rather than weaken, public confidence in the justice system. Meanwhile, I settled into a quieter rhythm of life, afternoons spent walking Rufus beneath the pecan trees, evenings in my study drafting op-eds on the interplay between mercy and law, and weekends visiting Malcolm's church to see the community work he established with at-risk youth. What I came to understand is that the resonance of one story can shift an entire culture. My own approach to judging, once laser-focused on procedure, now embraces the space for doubt, for follow-up, for deep listening. And while I no longer wear the robe, the lessons of those 40 years live on every time a courtroom lights flicker on, reminding me that our profession's true measure is found not in our certainty, but in our willingness to confront the unknown. Here's where I leave you. After 40 years of practice behind the bench, I've learned that the weightiest moments often come long after the gavel falls, in the quiet spaces between our convictions and our doubts. I used to believe that certainty was the cornerstone of justice, but my journey taught me that true justice demands a willingness to question, to listen, and, when necessary, to admit that we were wrong. I shared this story because I hope it sparks something in you. Maybe it's a reminder that every decision we make carries unseen consequences, or maybe it's an invitation to lean into the discomfort of doubt rather than dismiss it. So here's my final, bold question for you. One I've wrestled with every day since that stormy night. If you discovered that something you'd done, something you were absolutely certain of at the time, turned out to be a grave mistake, would you have the courage to open the door and face the person you'd wronged, even knowing it could upend your life? I'll be honest, that question still keeps me up at night. But if this tale has taught me anything, it's that our greatest power lies in confronting the unknown, even when it feels inconvenient or frightening. Now I want to know what it means to you. Share your thoughts below, challenge my perspective, and let's keep this conversation alive. Because at the end of the day, we all hold a gavel in our hands, whether it's the one behind the bench or the one that weighs on our own conscience. Which do you choose?